Welcome in, everyone. Goodness, I apologize for the disaster of a live stream I just tried to have between the internet going out, having to restart it twice, then my mic was muted. I apologize. So, what I'm going to do is go ahead and give this another try, go over the information, and hopefully you'll find it educational. All right, let's get into it. As always, the normal legal disclaimer. This video is for educational and informational purposes only and does not constitute formal legal advice. Debt collection laws are highly procedural. Always consult with a licensed attorney in your jurisdiction. For the purposes of this presentation, we're discussing North Carolina and Pennsylvania. The question is, you've received a judgment in the Commonwealth of Pennsylvania, but the person you received the judgment from is in North Carolina. Can you legally collect that civil judgment? Now, if you are someone living in North Carolina is famous for banning standard W-2 wage garnishments. Independent contractors or 1099 workers are a completely different story. In this video, we're going to go ahead and break down how exactly to domesticate an out-of-state judgment, say from Pennsylvania, and how to legally intercept 100% of the debtor's 1099 contract income. The award of attorney's fees, a judgment or an order in Pennsylvania, domesticating it or moving it to collect from somebody who lives in North Carolina. So, you won your case. For example, a declaratory judgment in Pennsylvania, and you've been awarded the attorney fees you paid to protect yourself against a potential legal action. For example, a cease and desist. Now what happens? Well, the person you won against lives outside of Pennsylvania, so there's a few extra steps that must be followed in order to collect the monies owed to you, the creditor, from the defendant, the debtor. First, you must domesticate the judgment in North Carolina. This grants your Pennsylvania order full faith and credit so you can legally seize assets under North Carolina law. North Carolina follows the Uniform Enforcement of Foreign Judgments Act, making this a streamlined process. You obtain an authenticated copy. You request an authenticated or exemplified copy of your judgment from the Pennsylvania Prothonotary, or in other jurisdictions you might know that as the clerk of courts or the court clerk, where the case was decided. You file in North Carolina. You file the authenticated judgment along with an affidavit confirming the balance due with the clerk of Superior Court in the North Carolina county where the debtor resides or owns property. You serve notice. You must properly serve the debtor with a notice of filing. There is a 30-day waiting period. The debtor has 30 days to seek relief from the judgment. If they do not respond, it becomes a final North Carolina judgment. Now you need to pursue collection. What is the remedy for this? Once domesticated, your judgment will be treated exactly like a North Carolina judgment. The following are methods or ways of collection. Bank levies. You can identify the debtor's bank and via a writ of execution instruct the sheriff to seize funds to satisfy the debt. Seizure and sale of personal property. The sheriff can locate and seize non-exempt personal property or vehicles to be sold at auction. Real estate liens. Your domesticated judgment immediately attaches a lien to any real estate the debtor owns in the North Carolina county where it is filed. And here's something that's important. It's called a debtor examination. If you don't know where the assets are, you can compel the debtor to appear in court under oath to disclose their financial information. A note on wage garnishments. Unlike many states, North Carolina does not allow standard W-2 earnings wage garnishment to collect civil judgments unless there's an underlying debt that involves, say, back taxes or child support or alimony. Now that we know that North Carolina doesn't allow for wage garnishment on a standard wage earner consistent with a W-2 status, what about someone that falls under a different status, say a 1099? That's a great question, and the answer may surprise all of you. Let's look at how that may work in the favor of the person that received the judgment. Because the debtor is a 1099 worker, you're not attempting a wage garnishment. Instead, you can legally pursue an accounts receivable levy or a third-party attachment. Why the North Carolina ban on wages no longer applies. North Carolina law strictly prohibits the garnishment of an individual's earnings for ordinary civil judgments. However, North Carolina courts have defined wages strictly as compensation paid by an employer to a W-2 employee. 1099 income is legally classified as a business contract payment, not wages. Because it is not a wage, it is completely exempt from North Carolina consumer wage protection laws. If you'd like further information regarding a W-2 versus a 1099, you can go to contractorsliability.com and go through the blog, and you'll find information about that. Intercepting 100% of a payment. For a W-2 employee status, where garnishment is allowed, a creditor can usually take only up to about 25% of the person's disposable paycheck. So that would be if you received a paycheck of $100, $25 could be taken right off the top to give to the creditor. For a 1099 independent contractor, you can serve a writ of execution directly to the company or client that pays the item. Under a third-party levy, you can legally demand 100% of those contract funds currently owed to the debtor until your judgment for attorney's fees is satisfied. And taken directly from the North Carolina Department of Revenue, if you report contract payments on a 1099, then collect 100% of the taxpayer's contract payments up to the amount of the total liability detailed in the notice. If you collect other types of funds, bank deposits, rents, royalties, or etc., which again would be your Venmos, PayPals, Cash Apps, coffee, donation, Zelle, anything of that nature, then collect 100% of these funds up to the amount of the total liability detailed in the notice. But once the garnishment is paid in full, the debtor would receive a release letter on that garnishment. And again, this is information that's taken directly from the North Carolina Department of Revenue, and those links are provided for you. How do you execute a 1099 levy? To collect the funds before they ever reach the debtor's hands, you must follow these steps. Identify the client. Use a debtor examination, a court-ordered financial disclosure, or forensic accounting, to find out who the debtor contracts with. Say, for example, a gig worker, DoorDash, Instacart, concert venue, security guard, or YouTuber, live streamer, Kick, Twitch, X, Facebook. Then you serve a writ. Once your Pennsylvania judgment is domesticated, have the North Carolina sheriff serve the writ of execution directly to the debtor's client, the company cutting the 1099 checks. Intercept the funds. The client is legally obligated to redirect the contract payments directly to the sheriff to satisfy your judgment, rather than paying the debtor. Meaning the person that receives the funds won't be able to cash them out. There's a lien on them. Alternatively, levying the debtor's bank account. If you do not want to alert the debtor's clients, you can wait for the 1099 funds to hit the debtor's bank account and execute a bank levy. Once the 1099 money is deposited into a personal or a business bank account, it loses any remaining earnings identity and can be frozen and seized entirely by the sheriff. Usually, instead of wage garnishment, creditors will levy the contractor or the freelancer's accounts receivable or bank account. This means your bank account will be frozen and potentially some, or all of the money in the account will be seized to pay the debt owed. Again, this is taken straight from North Carolina statute. And these are the North Carolina statutes. Property liable for sale under for execution is defines intangible personal property and accounts receivable as assets subject to a sheriff's levy. Here's the statute. Proceedings supplemental to execution authorizes the judge to issue an order in aid of execution commanding a third-party client to redirect funds to the creditor. And in this instance, the creditor is the person that owns the judgment. That's the statute for that. And garnishment of debt establishes the framework for attaching a third-party debt owed to a judgment debtor. And there is the North Carolina statute for that. Here is a list of links for resources. The Castle Law, there's, again, this relies heavily on the North Carolina Department of Revenue official government website. And if you go to these links, you can use the frequently asked questions search function or the drop-down menu. And in regards to the Pennsylvania Declaratory Judgment, you can locate that on palegislature.us under subchapter C. The link is provided. And a note of importance that I'd like to throw out here for y'all is this is not an advisory opinion. A declaratory judgment is not an advisory opinion. For declaratory judgment to be granted, there must be real, substantial, and immediate case or controversy between two parties. Courts do not rule on hypothetical scenarios. I appreciate y'all coming in. Again, let me apologize for the disaster of a stream previous if you were here for that. In the meantime, y'all be well, be joyful, and all the links are provided in this slide, in the description of the video, and will be in the pinned comment. Y'all have a great day, and I'll see you next time.